13. A mini dictionary of English law. Hey Alex, I've written something for you. It's a mini dictionary of English law. It's designed to get you acquainted with a lot of the terms and concepts you'll come across this year. My hope is that reading this through will help minimize the disorientation that you might experience in beginning to read about law, and help get you talking and thinking like a lawyer as quickly as possible. I've highlighted the most important terms and concepts that you will need to know about for this coming year. Incidentally, whenever you come across the abbreviation QV, which is short for Quad Vide, which means which see, that means that there is an entry in this dictionary for the term immediately preceding the abbreviation QV. Act of Parliament. See legislation below. Civil law. The term civil law has a couple of different meanings. First of all, the term civil law is used by English lawyers to describe that part of English law that determines what rights in the first sense of the word right QV private individuals enjoy against each other. Of the subjects you might study at university, tort law, contract law, land law, trusts law, family law, and labor law all belong to the field of civil law. Civil law, in this sense, is opposed to public law, which is the area of law which specifically governs relationships between public bodies and private individuals, and criminal law, which governs when the government may punish someone for behaving in an antisocial fashion. Secondly, civil law is often used along with Roman law to refer to the law of the old Roman Empire, on which the legal systems of many countries on the European mainland are based. These countries are often known as civilian or civil law jurisdictions as a result. Because of the importance of civil law in this secondary sense for the development of legal systems on the European mainland, many universities offer courses in civil law or Roman law. Claimant. Someone who commences litigation against someone else. Before 2000, someone who commenced litigation against someone else would be known as a plaintiff. The person against whom litigation is brought has always been known as a defendant. Common law. The term common law is used to refer to a few different things. First of all, the term common law is often used loosely to describe judge-made law. This is law that does not derive from a statute, but from the decisions of the judges as to what the law says in concrete cases. Technically, such decisions only amount to evidence of what the law says, with the judge in his or her decision expressing his or her opinion as to what the law says, which opinion is then binding on the parties to the case and creates a mini-law for their case. However, if it is clear that a particular opinion that the law says X would be accepted as correct by all the judges, then for the time being we can confidently say that the law does say X. And if the proposition X cannot be found in a statute, then we say that it is a piece of judge-made law and part of the common law. Such propositions include: a promise will only be legally binding if something of value in the eye of the law is given in return for it, or if it is made in a deed. Manufacturers of consumer products owe those who will ultimately use those products a legal duty to take care to see that those products are reasonably safe to use. A decision of a public authority can be set aside as invalid and of no effect if no reasonable public authority would ever make such a decision. There is no statute that says any of these things, but these propositions are still part of our law because they would be accepted as correct by the judges. Secondly, the term common law is sometimes used more strictly to describe areas of judge-made law that derive ultimately from the decisions of judges in concrete cases heard by the courts of common law. In the days when the English legal system had separate courts of common law and courts of equity, the common law courts would have general jurisdiction to hear all cases raising a legal issue. In contrast, the courts of equity would only hear a case if, in the view of the equity judges, there was a danger that applying the rules of the common law to the case would result in a serious injustice being done. So the courts of equity acted as a corrective to the common law courts, either granting a remedy to a deserving claimant who would not be entitled to a remedy from the common law courts, or by ordering on pain of going to prison for contempt of court. If the order were disregarded, a claimant who would be entitled to a remedy from the common law courts, not to pursue that remedy if it would be unconscionable to do so. In the 19th century, the distinction between courts of common law and courts of equity was abolished, and from then on the rules of common law and equity were supposed to be applied by a unified set of courts. But if a given bit of law has its origin in the decisions of the old courts of common law, lawyers will still mark that fact by referring to a common law interest, or common law action, or wrong at common law. And if it has its origin in the decision of the old courts of equity, lawyers will again mark that fact that by talking about an equitable interest, or an action in equity, or an equitable wrong. Thirdly, the term common law is sometimes used as a catch-all term to describe those countries whose legal systems are ultimately based on English law. So the United States, Canada, Australia, and New Zealand are the major common law countries outside England and Wales. In contrast, so-called civilian jurisdictions are those countries whose legal systems are ultimately based on civil law QV, that is, the law of the old Roman Empire. Most countries in Europe count as civilian jurisdictions. There is an entire subject, comparative law, that is devoted to comparing the common law approaches to various legal issues with the civilian approaches to those legal issues. Many universities offer their students the chance to interrupt their studies for a year to go to a civilian jurisdiction, usually France, to get acquainted with its distinctive system of law. Contract. Many people would say that a contract is a promise that is legally binding. However, there are many occasions when a promise will be legally binding on an individual without there being any kind of contract involved. It would be better to say that contract law provides people with a facility for making undertakings to each other that will be legally binding, and that a contract is what two people enter into when they take advantage of that facility. Courts. Below is a very simplified diagram setting out the names and relationships between the main types of courts that decide cases in England and Wales. The courts are arranged in a hierarchy, so that if you are unhappy with the result of your case, it may be possible to appeal to a higher court, either to have the result in your case reversed in your favor, or to have the higher court order that your case be reheard by a lower court. The highest court in the land is the Supreme Court of the United Kingdom. The highest court in the land was formerly known as the Appellate Committee of the House of Lords, but it was thought desirable on separation of powers QV grounds that there should not be any kind of link between the highest court in the land and the House of Lords, and that members of the highest court in the land should not have the power to sit in the House of Lords and contribute to its discussions of legislation. So the Constitutional Reform Act 2005 abolished the Appellate Committee of the House of Lords and put in its place the Supreme Court of the United Kingdom, which started hearing cases in 2009. Criminal cases are heard in either the Crown Court or Magistrates' Court, with appeals from those courts ultimately going to the Court of Appeal Criminal Division, and from there, if the Supreme Court gives leave, to appeal to the Supreme Court. Most of the non-criminal cases you will read as a student will have originated in the High Court. The Queen's Bench Division of the High Court typically hears cases involving disputes over land and claims for damages QV. A subdivision of the Queen's Bench Division is the Administrative Court, which considers applications for judicial review QV. The Family Division, as the name suggests, deals with all matrimonial disputes and child custody cases. The Chancery Division deals with a wide range of cases, typically centered around issues that would have been dealt with by the old courts of equity QV, so issues relating to equitable claims or interests, companies, and intellectual property will be dealt with by the Chancery Division. Appeals against decisions of the High Court can be made to the Civil Division of the Court of Appeal, and from there, if again the Supreme Court gives leave, to appeal to the Supreme Court. A quick note on names. If Adam Smith were a High Court judge, he would be known as the Hon. Mr. Justice Smith, or Smith J. for short. If Adam Smith were a judge in the Court of Appeal, he would normally be known as Lord Justice Smith, or Smith LJ. However, if Adam Smith were in charge of the Court of Appeal Criminal Division, He would be known as Lord Chief Justice Smith or Lord Smith CJ. And if he were in charge of the Court of Appeal Civil Division, he would be known as Lord Smith, Master of the Rolls, or Lord Smith Mar. If Adam Smith were a judge in the Supreme Court of the United Kingdom, he would be known as Lord Smith. Standing over all of these courts are the European Court of Justice and the European Court of Human Rights. The European Court of Justice is the ultimate authority on all issues relating to European Union QV law, and the UK courts must follow its decisions in deciding any legal cases that raise issues of European Union law. Any UK court is free to refer a case raising a tricky issue of European Union law to the European Court of Justice, which will give its opinion and then refer the case back to the UK court from where it came. The European Court of Human Rights is the ultimate authority on how the European Convention on Human Rights QV should be interpreted. Under the Human Rights Act 1998 QV, the UK courts are required to take into account the decisions of the European Court of Human Rights in determining whether someone's rights under the Convention have been violated. But they are, in theory, free to disregard those decisions where they think the European Court of Human Rights has got it wrong. Crime. A crime is an act or omission which is punishable under the law in some way, either through imprisonment or a fine, or in order to perform community service, or through some other sanction. It is often the case that the act or omission does not in itself amount to a crime. Instead, the act or omission will only amount to a crime if it is accompanied by a so-called guilty mind or mens rea. For example, it is not a crime to take a bar of chocolate off a supermarket shelf and put it in your pocket, but it is if you do so dishonestly, and with the intent to keep the bar of chocolate for yourself or somebody else. There are thousands of crimes recognized under English law. The crimes that make up the core of the criminal law are acts which involve someone's deliberately or recklessly violating someone else's rights in the first sense of the word, right QV. Crimes of this type include murder, rape, assault, battery, theft, criminal damage to property, and fraud. Around this core are thousands of crimes that do not necessarily involve the violation of anyone else's rights, but involve some form of antisocial conduct that Parliament has thought it necessary to discourage by making it criminal. Such crimes include speeding, possessing dangerous drugs, false advertising, selling goods by weight without providing a price by metric unit, traveling on a train without a valid ticket, and possessing a firearm without a license. Damages. Damages are a monetary remedy QV that may be sued for in a case where someone has violated someone else's rights in the first sense of the word, right QV. There are a few different types of damages. The principal form of damages is compensatory damages. These are designed, as the name suggests, to compensate a claimant QV for some or all of the losses that he or she has suffered as a result of someone's rights being violated. They aim to put the claimant in the monetary equivalent of the position that he or she would have been in had the rights violation not occurred. Of course, they often fall short of achieving that aim. English courts, sometimes though rarely, award exemplary damages against a defendant. These are designed to punish a defendant who has deliberately and outrageously violated a claimant's rights. Exemplary damages perform the same function as the criminal law, though without the controls that exist on when someone will be subjected to criminal punishment. For example, someone can only be held guilty of committing a serious crime QV if their guilt is established beyond a reasonable doubt. In contrast, someone can be held liable to pay exemplary damages if it merely seems more likely than not that he or she deliberately and outrageously violated a claimant's rights. Delegated legislation. Delegated legislation is legislation that is created by someone, almost always a government minister, who has been given the power to make law by an act of Parliament. The power to make delegated legislation is usually exercised by issuing what is called a statutory instrument. Delegated legislation, that is of some constitutional significance, is usually created by the Queen's issuing an order in council. Of course, the Queen will do as her government advises. The Terrorism United Nations Measures Order 26 was created in this way. This gave the Treasury the power to freeze someone's bank accounts if there were reasonable grounds for believing that he or she was involved in terrorist activities. This provision was later and rightly condemned by the courts as incompatible with people's rights under the Human Rights Act 2008 QV. There were 327 statutory instruments issued in 2012, in contrast to 23 Acts of Parliament. The creation of law through statutory instruments undermines the existence of the rule of law QV in the UK. The fact that so many statutory instruments are issued each year makes it impossible to keep track of what the law actually says. See also Henry Roman 8 clause below. Duty legal. Someone will have a legal duty to act in a particular way if they are required under the law to act in that way. If it has a legal duty to do X, we can say that that duty is a private law duty if it was imposed on a for the benefit of a particular individual B. In such a case, B is usually said to have a right QV that a do X, and if it does not do X, B will normally be entitled to sue A for damages QV. A's legal duty to do X can be said to be a public law duty if A is a public body, and that duty was imposed on A to help ensure that A acts in the public interest. A breach of a public law duty is normally remedied through an application for judicial review QV, though it may also amount to a crime QV, for which it can be prosecuted. Equity. See Common Law above. European Convention on Human Rights. The European Convention on Human Rights, ECHR, for short, was created by the 47 member states of the Council of Europe in 1950. Signatories to the convention, which include the United Kingdom, as well as non-EU countries such as Russia, Switzerland, and Norway, agreed to observe certain fundamental rights and freedoms, including the right to life Article 2, the right not to be tortured or subjected to inhuman and degrading treatment Article 3, the right to liberty and security of person Article 5, the right to a fair trial Article 6, the right to respect for one's private and family life Article 8, and the right to freedom of expression Article 10. Since its inception, the convention has been supplemented by a number of protocols. Signatories to Article 1 of the first protocol undertake to respect people's rights to peaceful enjoyment of their possessions. The European Court of Human Rights, ECHR, for short, was set up in Strasbourg, France, to monitor whether signatories to the convention were in breach of their obligations under the convention, and to provide a satisfactory remedy in cases where someone had suffered loss as a result of a signatory's failure to abide by its obligations under the convention. For example, a prisoner in the UK who was denied access to a solicitor could complain to the ECHR that the UK government was violating his right to a fair trial. And if the court found that the complaint was justified, it would order the UK to compensate the prisoner for the violation of his rights and to cease violating his rights. If the UK did not comply with this order, it would be in breach of its obligations under the ECHR, which would be embarrassing both at a political and public relations level. So in practice, the UK does comply with orders of the ECHR. The need for UK citizens to take cases to the ECHR has been lessened by the enactment of the Human Rights Act 1998, which imposes on public authorities a legal duty QV not to violate people's rights under the ECHR. A claimant QV who alleges that he has suffered loss as a result of a public authority breaching this duty may now take his case to be heard by an English court, which will grant a satisfactory remedy if taking into account the Ecker's interpretation of the ECHR. It is persuaded that the claimant's rights under the ECHR have been violated. The UK Parliament QV is exempt from this duty. If it were not, the traditional rule of parliamentary sovereignty QV over the courts would have been abolished. But in cases where it is alleged that Parliament has passed legislation QV that violates people's rights under the ECHR, the courts have the power to issue a declaration of incompatibility, saying that the legislation is in violation of the ECHR. In such a case, political and public relations considerations could be expected to force Parliament to repeal the relevant legislation, It is a common mistake of students and journalists to think that the ECHR has something to do with the European Union QV. This is quite wrong. The ECHR has nothing to do with the EU. At the time I am writing this letter, the EU, as distinct from the member states of the European Union, is still not a signatory to the ECHR, though it is in the last stretch of negotiations to accede to the ECHR. In the past, this meant that the institutions of the EU were not bound by the ECHR, and were therefore not required to respect, for example, the freedom of speech of whistleblowers exposing corruption within the EU. To eliminate this loophole, the Lisbon Treaty gave effect to a Charter of Fundamental Rights that was binding under EU law, both on the institutions of the EU and the member states of the EU. Though the UK insisted on a protocol being inserted into the Charter, which would stop the Charter applying to the acts, laws, regulations, or administrative provisions, practices, or actions. European Union. The European Union, EU for short, is an organization of 27 European states, including the United Kingdom, bound together by a series of treaties, such as the Treaty of Rome 1957, the Maastricht Treaty 1992, and the Lisbon Treaty 27, which commit the member states of the EU to maintain a single market within the borders of the EU, within which borders there is to be free movement of peoples, goods, services, and capital, and to pursue common policies on a range of other areas, such as agriculture and fishing. To achieve these objectives, there exist a range of different European institutions. The EU is run on a day-to-day basis by the European Commission, which comes up with suggestions for legislation that might be created by the EU's legislature. The EU's legislature is made up of the European Parliament, which is, in turn, made up of elected representatives from all regions of the EU, and the Council of Ministers, which is made up of ministers from each of the member states of the EU, with the ministers making up the Council at any one point, varying according to what the Council is discussing at that time. The United Kingdom has been a member of the EU at the time, the European Economic Community, since 1973. Under the European Communities Act 1972, provisions in any treaty entered into by the member states of the EU automatically become part of English law and override any inconsistent parts of English law once the treaty is approved by the UK Parliament. Any regulations created by the EU's legislature will automatically become part of English law and automatically override any inconsistent elements in English law, irrespective of whether those elements predate or postdate the regulation in question. Again, as a result of the European Communities Act 1972. The EU's legislature is also empowered to issue directives to the member states of the EU, requiring the member states to change their national laws so that the law on a particular point or issue is the same across the EU. For example, Council Directive 85/374/EC directed each member state of the then European Economic Community to change its law so that the manufacturer of a dangerously defective product that did harm to someone's person or property would be held strictly liable for that harm, that is, without the need to prove that the manufacturer was at fault for the existence of that defect. That directive was implemented in the UK by passing the Consumer Protection Act 1987. Directives are more usually implemented through the issuing of a statutory instrument, which is a form of delegated legislation QV. If a member state of the EU fails to implement a directive correctly, it is required under EU law to compensate anyone who suffers financial loss as a result of that failure. Who says so? The European Court of Justice (ECJ), for short, which so ruled in the case of Frankovic v. Italy. The ECJ, which is based in Luxembourg, is the ultimate authority on all issues of EU law. It interprets the treaties of the EU and the legislation issued by the European legislature, and decides such issues as whether a member state has failed to implement a directive correctly, or whether a particular aspect of the domestic law of a member state is inconsistent with an EU regulation or treaty provision. In theory, a member state of the EU is free to disregard an order issued against it by the ECJ, just as a member state of the EU is free to disregard a directive that has been issued by the European legislature, but doing so would put it in breach of its obligations as a member of the EU. and put its continued membership of the EU in question. Henry Roman 8 Clause. A Henry Roman 8 clause is a provision in an Act of Parliament QV that empowers a government minister to change the terms of an Act of Parliament or a statutory instrument QV. Such a provision is called a Henry Roman 8 clause because the Statute of Proclamations 1539 gives us a very early example of such a provision. That act provided that Henry VI's proclamations had the full force of law, as though they were made by Act of Parliament. Examples of very wide Henry Roman 8 clauses are provided by Section 1 of the Legislative and Regulatory Reform Act 2006. A minister of the Crown may by order make any provision which he considers would remove or reduce any burden, or the overall burdens, resulting directly or indirectly for any person from any legislation. Sections 1924 of the Civil Contingencies Act 2004. Which provide that Her Majesty by order in council, i.e., the government, may create emergency regulations that have the effect of disapplying or modifying an enactment or a provision made by or under an enactment, if it is urgently necessary to make provision for the purpose of preventing, controlling, or mitigating an aspect or effect of an emergency. An emergency is defined as, among other things, an event or situation which threatens serious damage to human welfare in the United Kingdom or in a part or region. Human Rights Act 1998. See European Convention on Human Rights above. Judicial review. A claimant QV who brings an application for judicial review is asking a court to determine whether or not a public body exceeded its powers in Latin, acted ultra vires in making a particular decision, or in acting in a particular way, or in failing to act in a particular way. If the court finds that the public body is exceeding, or has exceeded, its powers in acting in a particular way, there are a variety of remedies QV that the court could award. In the case where a public body has made a decision that is ultra vires, for example, deciding to grant planning permission to a company to construct a supermarket, the court could issue an order of certiorari, quashing the decision. In the case where a public body has exceeded its powers by failing to act in a particular way, for example, by refusing to consider someone's objections to the construction of a new supermarket in a particular location, the court could issue an order of mandamus, ordering the public body to act in that way. In the case where a public body is continuously exceeding its powers by acting in a particular way, for example, by making a yearly grant to a company in return for its running a supermarket in a particular location, the court could issue an order of prohibition, ordering the public body to cease acting in excess of its powers. There are a number of different reasons why a court might find that a public body has acted, or is acting, in excess of its powers. The public body may have misinterpreted the powers granted it by a particular piece of legislation, thereby making an error of law, or made an error of fact which made it think it was empowered to act in a particular way, when in fact it was not. The public body may have used the powers granted it by a particular piece of legislation for an improper purpose, or may have exercised those powers in a way that no reasonable person would have exercised them. The public body may have exercised its powers without granting someone affected by them a fair hearing before deciding what to do, or the person making the decision as to how the public body should exercise its powers may have had a financial interest in the public bodies exercising its powers in the way it did. Finally, the public body may have acted in a way that violated someone's rights under the European Convention on Human Rights QV, something which it is barred from doing under the Human Rights Act 1998 QV. Virtually all public bodies are susceptible to having their decisions and actions challenged through an application for judicial review. The major exception to this rule is that no one can make an application for judicial review to ask the courts to quash an act of Parliament on the ground, for example, that no reasonable person would have created such an act, or that it violates someone's rights under the European Convention on Human Rights. Though in the latter case, it is open to the courts to make a declaration of incompatibility between the act and the convention. This is because of the doctrine of parliamentary sovereignty QV. No such bar to judicial review applies in the case of delegated legislation QV. For example, If a minister creates a statutory instrument QV, under legislation empowering her to do so, a claimant could make an application to the courts, asking for the statutory instrument to be quashed on the ground that the minister exceeded her powers in creating that instrument, for one of the reasons set out above. Jurisprudence. In ancient times, the term philosophy was used to describe the study of the entire field of human knowledge. The word philosophy is derived from the Greek philos meaning love and sophia meaning knowledge. But then different branches of knowledge acquired their own titles: mathematics, physics, biology, chemistry, and were hived off from philosophy, which simply came to describe whatever we study when we don't study mathematics or physics or biology or chemistry. Or the same thing has happened to the term jurisprudence, which used to describe the entire field of legal studies, so that an undergraduate who obtains a law degree from Oxford is still said to obtain a BA in jurisprudence. But as different branches of the study of law have acquired their own titles: contract law, tort law, criminal law, public law, those branches have become distinct from jurisprudence, which has simply come to describe whatever we study when we study law, but don't study contract law, tort law, criminal law, public law. As such, jurisprudence, as a subject, is now concerned with theoretical issues affecting the other branches of legal study, such as: what is law? How do we tell what the law says on a particular issue? Can the law on a particular issue ever be certain? Is it ever justifiable to punish someone for acting in a particular way? What is the basis of the remedies that courts award when someone's rights QV have been violated? Legislation. Legislation is law that has been deliberately created by a law-making body. There are two forms of legislation in English law. First, primary legislation, which is made up of laws contained in Acts of Parliament passed by Parliament QV. Second, delegated legislation QV, which is made up of laws created by someone, usually a government minister empowered to make law by an act of Parliament. Some say that judges act in a legislative capacity when they decide cases where the law is uncertain, that they make new law in deciding the case. The better view would seem to be that judges hardly ever act as legislators. In other words, a judge hardly ever decides a case with a conscious intention: I will now lay down what the law will say on this particular issue from now on. Instead, he will express his opinion on what the law says on that issue, and then wait to see if his fellow judges will accept his opinion. If they do, then his opinion will represent the law for the time being. If they do not, then his opinion won't be worth the paper it was written on. But unlike a true legislator, no judge acting alone has the power to affect what the law says. Omission. English law draws a big distinction between acts and omissions. Roughly speaking, acts make people worse off. Omissions merely fail to make people better off. If I run you over in my car, that is an act. If I fail to shout out a warning when I see that you are in danger of being run over by someone else, that is an omission. Under English law, you have lots of rights in the first sense of the word, right QV, that other people not make you worse off. But rights that other people make you better off are much rarer. You have a right against everyone that they take care not to do something that foreseeably would cause you physical injury. But if you are in danger of suffering some kind of physical injury, you will only normally have a right against someone that they take care to save you from that danger, if you are in a special relationship with them. A complete stranger will not normally be under any kind of duty QV to save you from that danger. As a result, he will not normally commit any kind of tort QV or crime QV if he leaves you to your fate. Parliament. Under the UK Constitution, the Parliament of the United Kingdom has the power to make law for the UK. Under the doctrine of parliamentary sovereignty QV, there are no restraints on how this power may be exercised. The Parliament of the United Kingdom is made up of three parts: the House of Commons. This is currently made up of 646 members of Parliament, MP for short, each of whom represents a constituency within the UK and was elected to Parliament by that constituency. Almost all MPs belong to a party. The party that has an absolute majority of MPs makes up the government, with the leader of that party acting as Prime Minister, the House of Lords. This is currently made up of 740 members, almost all of whom were appointed to serve in the House of Lords by the sovereign, acting on the advice of the Prime Minister, who in turn allows the other parties in the House of Commons to nominate people to represent their interests in the House of Lords. The sovereign. The sovereign is the head of state and is currently Queen Elizabeth Roman II. Parliament makes law by considering proposals to change the law, known as bills. Bills are almost always introduced into Parliament by the government, though MPs are also given some parliamentary time to offer their own bills for approval by Parliament. Normally, for a bill to become an Act of Parliament, it has to be approved by all three parts of the Parliament of the United Kingdom. The Parliament Acts of 1911 and 1949 placed a limit on the power of the House of Lords to stop a bill becoming an Act of Parliament by refusing to approve it. A bill dealing with taxation, and a bill that has been approved by the House of Commons in two separate sessions, can become an Act of Parliament without the approval of the House of Lords. The approval of the sovereign, known as the royal assent, is always required for a bill to become an Act of Parliament. In practice, the sovereign never refuses to give the royal assent to a bill that is presented to him or her for approval. However, the fact that the royal assent is required to turn a bill into law is thought by some to be a residual bulwark against a government, using its majority in the House of Commons to install itself permanently in power as a dictatorship. Parliamentary sovereignty. The doctrine of parliamentary sovereignty has two sides to it. The first deals with the relationship between Parliament and the courts. The second deals with the relationship between the current Parliament and future parliaments. The doctrine of parliamentary sovereignty says, first of all, that the courts will be required to give effect to each provision in an Act of Parliament until that provision is repealed by a subsequent Act of Parliament. And this is so no matter how objectionable that provision may be. In other words, the courts are subordinate to Parliament. The doctrine of parliamentary sovereignty says, secondly, that any Act of Parliament can be repealed by Parliament, and that an Act of Parliament that has been repealed will no longer have any legal effect. In other words, Parliament cannot bind its successors. It follows from this that Parliament cannot place any hurdles in the way of a future Parliament repealing a given Act of Parliament that would make that Act harder to repeal than it was to pass. In other words, Parliament cannot entrench legislation, protecting it against successor parliaments that might want to repeal it. The doctrine of parliamentary sovereignty is fundamentally democratic in nature. It proclaims the supremacy of the elected legislature over unelected judges, and the current legislature, which represents the current views of the people over previous legislatures. Given this, it might be wondered whether there should be an exception to the doctrine of parliamentary sovereignty, where a parliament attempts to undermine democracy by, for example, passing laws against public demonstrations, or by passing laws that make it easier to engage in corrupt electoral practices. But so far as we know, the courts would not make an exception to the doctrine of parliamentary sovereignty in such cases. However, there are two major exceptions to the doctrine of parliamentary sovereignty. First, a provision in an Act of Parliament will not be given effect to by the courts if it is inconsistent with European Union QV law as incorporated into English law by the European Communities Act 1972, unless Parliament has made it absolutely clear that it is to be given effect to even if it is so inconsistent. Secondly, Parliament is free within as yet unspecified limits to pass legislation that will have the effect of changing the definition of what counts as an Act of Parliament. It remains uncertain whether this power can be used to entrench either other legislation. An act purporting to repeal the Human Rights Act 1998 will not count as a valid Act of Parliament, or the very legislation that has the effect of changing the definition of what counts as an Act of Parliament. An act that purports to repeal this legislation but does not command the support of 75% of the House of Commons will not count as a valid Act of Parliament. Precedent. A precedent is a legal case that has been decided by some court in the past. A binding precedent is a legal case that was decided by a court on the basis of some rule or principle, which other courts must give effect to under the rules of precedent, if they have to decide a case where that rule or principle applies. Under the rules of precedent, decisions of the Supreme Court of the United Kingdom and the Appellate Committee of the House of Lords are binding on all UK courts QV, other than the Supreme Court of the United Kingdom unless and until they are overruled, declared no longer to be correct by the Supreme Court, or have already been overruled by the Appellate Committee of the House of Lords. Decisions of the Court of Appeal are binding on future courts of appeal, and all courts lower than the Court of Appeal, unless and until they are overruled by the Supreme Court, or have already been overruled by the Appellate Committee of the House of Lords. A persuasive precedent is a case that was decided by a court on the basis of some rule or principle, which another court is not bound to give effect to under the rules of precedent. But the legal wisdom and authority of the judges who decided that case is such that it is likely that other courts will accept that rule or principle as being correct. The rules of precedent are rendered less important than you might think, because of the fact that it almost always a matter of debate what rule or principle underlay a decision of a court in a particular case. So, for example, if the Supreme Court decides in Doe v. Brown that Doe must pay Brown damages QV, the Court of Appeal will be bound by that decision. At the same time, it will usually be a matter of debate what rule or principle underlay the decision of the Supreme Court in Doe v. Brown. If this is so, it will be up to the Court of Appeal to decide for itself what rule or principle underlay the Supreme Court's decision in Doe v. Brown, and therefore what rule or principle it is going to be bound by under the rules of precedent. Property. Lawyers use the term property to refer to three different things, and are not always careful enough about distinguishing between them. They use the term property to refer, first of all, to the things that can amount to property. These things are separated into two categories. First, tangible property. This category is made up of things that can amount to property that you can touch, such as land and cars and computers and CDS. Secondly, intangible property. This category is made up of things that can amount to property that you cannot touch. Intangible property always takes the form of a right in the second and third senses of the word right QV, of some kind. For example, copyrights, which give someone the right not to have their work copied by someone else. Patents, which give someone the exclusive right to exploit a particular invention. Rights to draw money from a bank account. And rights to sue someone for money. Lawyers also use the term property to refer, secondly, to the interests that one can have in a thing that amounts to property. The greatest interest one can have in such a thing is legal ownership. But English law recognizes many other interests that one can have in a thing, such as equitable ownership, otherwise known as a beneficial interest, a lease, and a charge. These interests can be traded, and can be held simultaneously in the same thing by different people. So a piece of land could be legally owned by A, but at the same time B has a beneficial interest in it, in which case A is said to hold the property on trust for B, and the land is leased out to C for a year. And D Bank has a charge over the land to secure the money D Bank lent it to acquire the land. Lawyers also use the term property to refer, thirdly, to the rights in the first sense of the word right QV, that someone who has an interest in property will have that others not interfere with that interest. So someone who legally owns a thing will have rights against virtually everyone else that they not interfere with his ability to enjoy and exploit that thing. If B has a beneficial interest in a thing that is legally owned by A, B will have a right against A that A exploit that thing for B's benefit. If C leases a thing that is legally owned by A, C will have a right against virtually everyone else, including A, that they not interfere with her ability to enjoy and exploit that thing for the duration of the lease. If D Bank has a charge over a thing legally owned by A, it will have a right against A that A sell that thing and use the money realized by the sale to pay off a debt that A owes D Bank. D Bank will not, of course, seek to enforce this right, unless it becomes worried about A's ability to pay off his debt to D Bank without selling the thing that D Bank has a charge over. Remedy. Remedy is a catch-all term for the range of orders, awards, and sanctions that a claimant QV who brings a case to court may be seeking. In a case where a claimant complains that a defendant has violated his rights in the first sense of the word, right QV, the normal remedy that he will be seeking is damages QV. But in a case where a defendant is continuously violating the claimant's rights, the claimant may also seek an injunction, an order of the court that the defendant stop violating the claimant's rights. Disregarding such an order after it has been issued will amount to a contempt of court, which is a crime QV, punishable by imprisonment. A claimant may bring a case seeking a declaration that he has an interest in a particular piece of property QV that is being held or exploited by the defendant, and that as a result he has certain rights against the defendant in the first sense of the word, right QV. A claimant may also bring an application for judicial review QV against a public body, seeking a range of remedies designed to ensure that that public body does not exceed its powers, right legal. Confusingly, lawyers use the term legal right to describe three different things: the situation where the law imposes on B a duty to do X, and that duty is imposed on B purely for A's benefit. In such a situation, lawyers say that A has a legal right that B do X. For example, A has a legal right that B not harass him, or A has a legal right that B take care not to injure him. The situation where the law gives A the power to perform a particular legal act, such as suing someone, or entering into a contract with someone else, or making someone your agent. In such a situation, lawyers say that A has a legal right to perform the act in question. For example, A has a legal right to sue B for damages, or A has a legal right to terminate his contract with B. The situation where the law protects to a limited degree some freedom or interest of A's against being interfered with by other people. In such a situation, lawyers say that A has a legal right to enjoy that freedom or interest. For example, A has a legal right to freedom of speech, or A has a legal right to enjoy his property, or A has a legal right to bodily integrity. The fact that the word right is used in these different ways creates room for confusion, either on the part of the person using the word or the people he or she is speaking to. For example, suppose that Freddie is making a controversial speech at Nantwich University, and some student protesters are trying to shout him down. Freddie may try to silence the protesters by claiming either to them or the police that he has a right to freedom of speech, and that they should respect that. But in saying this, he is trying to pull a fast one. He does indeed have a right to freedom of speech, because the law to a limited extent protects his freedom of speech from being interfered with by the government. But that has nothing to do with the protesters. Unless the law gives Freddie a right in sense 1, above that the protesters not shout him down, which it does not. Unless their conduct amounts to unreasonable harassment, the protesters are free, and should feel themselves free, to make as much noise as they want. Rule of law. Academics use the term rule of law in a number of different ways. First, some use the term rule of law to describe the conditions that have to be satisfied if a legal system is to work effectively as a legal system, that is, as a system for guiding people's behavior by laying down rules for them to follow. Such people say that the rule of law demands that a legal system's laws be certain, consistent, prospective, easy to understand, easy to remember, easy to find out. It also demands that people generally must be inclined to obey the law, and there must exist effective remedies and sanctions that are applied to those who are not willing to obey the law. Secondly, some think of the rule of law as the antithesis of the rule of men, as in the phrase, "We live under the rule of law, not men." According to this view, we can only say that we live in a country governed by the rule of law if 1. Our country's legal system places strict limits on when the state may use coercive force against someone. 2. Those limits are normally observed. And 3. When those limits are violated, there exist effective remedies and sanctions that are applied against the state. Thirdly, others think that if the ideal of living under the rule of law, not men, is to be achieved, the power to make law must be constrained. so that those who make the law are themselves subject to a higher law in the way they exercise their power. On this view, we can only say that we live in a country governed by the rule of law if, in addition to 1, 2, and 3, above 4, there exist mechanisms in our country that work effectively to ensure that the power to make law is not exercised arbitrarily or irrationally or immorally. Separation of powers. The French philosopher Montesquieu 1689–1755 praised the British Constitution for splitting the government into 3 different branches: the legislature, which makes the law; the executive, which enforces the law and employs the power of the state within the limits placed on it by the law; and the judiciary, which interprets the law and resolves legal disputes. This arrangement, he claimed, prevented governmental power being concentrated in the hands of any one person or one group of people, and therefore helped to ensure that governmental power was not abused. It seems obvious that Montesquieu's analysis of the British Constitution no longer holds true, if it ever did. There is no longer an effective separation of powers within the UK of the type Montesquieu advocated. The fact that the leading figures in the government are drawn from the majority party in the House of Commons, and the fact that the House of Lords cannot block legislation that the majority party in the House of Commons is determined to introduce, means there is no longer any solid dividing line in the UK Constitution between the legislature and the executive. The line is dissolved even further by the existence of delegated legislation QV, which is legislation created by government ministers, and Henry Roman VIII clauses QV, which allow government ministers to rewrite acts of parliament after they have been passed. Turning to Montesquieu's third branch of the government, while the judiciary is theoretically independent of the executive under the UK Constitution, the law reports contain very few cases where the courts have decided a case in a way that is seriously embarrassing for the government. There are, in contrast, plenty of cases where the courts have reinterpreted and twisted the law to avoid deciding cases in a way that would embarrass the government. In practice, the courts are careful not to exercise their powers in a way that might provoke a seriously adverse reaction from the all-powerful executive. Statute. See Parliament above. Statutory instrument. See delegated legislation above. Tort. A tort involves the violation of a legal right in the first sense of the word right QV that does not arise from a contract QV, and which may be remedied through the award of damages QV. There are a large number of different torts recognized under English law, corresponding to the large number of legal rights that English law endows people with even before they have entered into a contract with someone else. The range of torts recognized under English law include trespass to the person touching someone else without justification battery, threatening someone else without justification assault, and locking someone else up without justification false imprisonment, trespass to land going onto someone else's land without justification, negligence failing to take care not to injure someone or protect their interests when they had a right that you take such care, and defamation damaging someone's reputation without justification. So that's my mini dictionary of law. I'd recommend that you read this through a few times before you start studying law. Once you are completely familiar with it, you should be able to hit the ground running when your studies begin. Having said that, it would be a good idea for you to buy a dictionary of law, as you will be coming across a lot of other strange words and concepts in the course of your studies that you will need to come to grips with. Elizabeth Martin and Jonathan Law's A Dictionary of Law looks really good, as does Leslie B. Curzon and Paul Richards' Dictionary of Law. If you have a lot of money, it might also be worth investing in the new Oxford Companion to Law, edited by Peter Kane and Joanne Canagan. Best wishes, Nick.